Well, welcome everyone, and thank you for joining us. My name is Randy Lupke, and I'm the president and founder of Lifetime Paradigm. We are registered financial consultants and independent fiduciary advisors that provide real estate integrated and self-directed financial consulting, advising and coaching to business owners and real estate investors. And as we get into the workshop tonight, which will be about the Secure Act, I want to start with talking about our disclosures. This is an educational webinar. This is not to give you any specific tax, legal, or investment advice. And it's important, and I know we see these disclosures all the time, but it's really important for us to let you know we consider the information that we're going to be providing to you to be accurate and reliable. But as the small print says there, be sure, of course, to talk to any licensed advisor to get specific advice before you make any decisions, rely on the opinions that we're going to share with you today. So let's jump right into the webinar. What we're going to cover, first of all, we're going to talk about 3 new and distinct groups of beneficiaries to deal with the Secure Act. We're going to talk about post-death distributions for stretch IRAs, 401ks, and other retirement accounts, all types of retirement accounts. And we're going to talk about a new category of beneficiary that's exempt from all these new rule changes. By the way, this Secure Act, which was passed at the end of 2019, is considered to be a significant law that was put into place, and it's going to literally affect millions of people. So I'm glad you're taking the time to listen to this webinar and learn how it might affect you. You're also going to learn about how the Secure Act changes will affect spouses of a decedent, disabled and chronically ill persons, as well as minor children, and also going to talk a little bit about retirement plans. So let's jump right in and start drilling down on the topics that we're going to talk about. The first one being the 3 new categories of beneficiaries. So number 1, 2, 3, eligible designated beneficiaries, and the non-designated beneficiaries. Thank you, IRS, for making things nice and complicated. Eligible designated beneficiaries are basically beneficiaries, people that would inherit an IRA or one of these retirement accounts, that are still eligible to take advantage of the stretch options, stretch IRA options that most people enjoy today. And we're going to talk a little bit more about what stretching means, how these changes are going to affect it, but only this group of people will now be eligible to take advantage of the stretch, which means most people are either going to fall into the designated beneficiaries area, which is now the 10-year rule. And again, we'll drill down on each of these. And then the bulk of the inheritors will fall into the category of the non-designated beneficiaries, and they're going to be subject to the 5-year rule. So let's drill down. Eligible designated beneficiaries. That means they're eligible for the stretch. Like I said, could have made it simpler, IRS, but they don't do that. So who's going to be eligible to stretch their IRA? Well, minor children of the decedent while they're minors. So if grandpa were to give his IRA to his grandson or granddaughter, that minor would be able to use the stretch IRA based on their age, and not be forced to take out withdrawals from the IRA based on grandpa's age, until the grandchild, or this example, would become an adult. And the age of majority, the adulthood for minors, varies from state to state, so that will have some impact on it depending on where the minor resides, I should say. But minors do have the ability to stretch the IRA. Disabled persons, same thing. They'll be able to stretch the IRA. People that are chronically ill. People that are less than 10 years younger than the decedent will also be able to stretch the IRA, and spouses will be able to stretch the IRA. And we're going to talk a little bit more about spouses in general, because spouses really have a lot of special features that are available to them that aren't available to any other inheritor of a retirement account. And then lastly, certain trusts that address beneficiaries properly. And most trusts, by the way, don't, but there are some trusts that are out there and provided by the attorneys that will have what's called a see-through provision. And that see-through provision allows the basically the IRS to see through the trust, and there would be a named beneficiary underneath that. And so while the trust controls the distribution, there's a beneficiary there, and therefore those trusts are still going to be eligible for a stretch. So that's all the beneficiaries that fall into Category 1. So let's talk about what a stretch is for a moment. Stretch, we call them stretch IRAs, but it's stretch retirement accounts. So basically, owners of retirement accounts are required to take distributions at age 70 and a half. That's now been changed to 72. We'll deal with that a little bit in a moment, again, as a result of the Secure Act. So the owners, once they turn 70 and a half, the year they turn 70 and a half, they have to start taking distributions. That's why they call them required. And the amount they have to distribute is based on the amount of money inside the retirement plan and then the age of the owner. And as you get older, you have to take out more and more and more. So stretching was a terrific tool because, again, grandpa, who, let's say grandpa's 85 years old and then passes the IRA and has already been taking RMDs, right, because he's way over 70 and a half, and taking pretty big ones at that age, passes that IRA down to the grandson, and now the grandson would be able to take the distributions based on the grandson's age. So that allows the money to stay inside the IRA, compounding deferred for many, many, many more years, and that's why the stretch was so important. So that's what a stretch is. Inherited IRAs, RMDs is based on their age, not the owner. So that's the important part. And then the Secure Act made significant changes to these, and that's what we're going to cover. Okay, so designated beneficiaries, the second category of our three new categories, no more stretch. They're now in the 10-year rule. So if I'm not one of those designated beneficiaries, eligible beneficiaries, I'm a designated beneficiary, and I have to take all the money out of the IRA over a 10-year period. No more stretch. Right? Now, you don't have to take it out in equal installments. You can take it out in small amounts and then larger amounts in the end, or whatever you want to. But by the end of the 10th year, every penny inside that IRA has to be distributed by that designated beneficiary. Those who are the designated beneficiaries, those are non-spouses. So it could be children, right? It could be certain trusts that address beneficiaries properly as well. They could be designated beneficiaries. Now, I mentioned spouses earlier. Spouses are special. Why? Well, they can do a couple different things with IRAs that nobody else can do. First of all, they can continue to own that IRA or manage that IRA, I guess is a better way to say it, as an inherited IRA. So it's not theirs, it's an inherited IRA. However, because they're the spouse of the decedent, they have the ability to withdraw from the IRA before age 59 and a half, and they're not going to be subject to any penalties. So if you take let's say we had a 70-year-old husband who had a 50-year-old wife, and we'll go with that as an example, and he passes away. The 50-year-old wife, if money was in her IRA and she tried to take the money out because she's not 59 and a half, she would have to be subject to the 10% penalty. But she can take money out of her deceased husband's IRA with no penalties. So spouses are special in that regard. The other area they're special in, they can roll that inherited IRA into theirs, and nobody else can do this. Inherited IRAs stay the inherited IRA forever, well, until the money's gone. But a spouse doesn't have to do that. So what that means is, again, using this example, the spouse could wait, and she would have to take RMDs, and she would have to take them at the age of her husband finally turned 70 and a half, or would have turned 70 and a half. But it's still that inherited IRA. So she could do that, but if she wanted to, she could then roll the inherited IRA into her IRA, and now she wouldn't have to take any withdrawals. She wouldn't have to do any RMDs because she's not 70 and a half. Well, now 72. So spouses are special. Again, if you are a spouse or know of somebody that's inherited an IRA, you want to consult with both your tax professional as well as your financial advisor to make sure that you take title the correct way and get the most benefit out of that inherited retirement fund money. Now, Number three, the non-designated beneficiaries, everybody else. This is the 5-year rule. This is always in place before. So anybody that inherited an IRA and they were not a designated beneficiary, which would be charities, that would be inheritors through a will. So if you name somebody in a will that they're going to get your IRA, then they're a non-designated beneficiary, and they have to drain that thing out in 5 years. And most trusts that don't address beneficiaries properly. And again, most living trusts that we see in the wild today are not set up properly to be able to pass retirement accounts through to designated beneficiaries to allow them to be stretched. They're not designed that way, and that's why in general we encourage our clients to consider not putting retirement plans into a trust, but just to designate a beneficiary with the IRA custodian directly, and that way the IRA passes directly to the beneficiary, doesn't go through probate. But if you are concerned about the person that would be receiving the trust, maybe you want to provide creditor protection or other benefits that you would get from a trust, then you need to make sure that the trust you have will allow for that see-through provision. And so you want to consult with your estate planning attorney and make sure it has that if that's where you want to go. But again, number three, non-designated beneficiaries, they got to empty that money out in 5-year period. All right, so in review, we have 3 new categories of beneficiaries. We have the eligible designated beneficiaries. They get the modified stretch. They're eligible for a stretch. We have the designated beneficiaries. These are people that are directly by the custodian going to receive the inherited IRAs. They have to drain those out now in 10 years. And then finally, we have our non-designated beneficiaries, and they have to drain those IRAs out in 5 years. Right, so you can see what's going on here. The IRS is saying, look, we want to get these, we're going to give you the benefit of contributing pre-tax into these retirement plans. We're going to give you the benefit of allowing the money and the investments inside the retirement plans to grow tax deferred, but we want our money and we want it sooner than later. And now they basically have created a law that forces the distribution of those funds so that the taxes are paid. Okay, now I mentioned that there were some exemptions to these distribution terms, and because these don't affect a lot of people, I'm not going to go over them in any detail at all, just to say that there are some exemptions. They'll be included in the PowerPoint, and obviously this webinar is also being recorded. So if you go to this section, you can read through them, and if it affects you, then again, consult with your financial advisor and or attorney and tax person and decide what strategies you need to deploy because you're now exempt from this law. All right, now this is a big list of things, and I'm not going to gloss over it. I'm going to drill down at various levels with each one of these elements of the Secured Act. Some are going to be more relevant to larger groups of people, and some will be more important than others, but we're going to drill down on them. And the bottom line is, which is really the top line here, our government wants you to save for retirement, right? They recognize that that most people don't have pensions anymore. Those pensions started going away in the 70s with the advent of IRAs and then 401ks, and as a result, they want to again encourage people to put money into these retirement accounts so that when they do retire, that they have money to live off of. So, what do we have? Number one, we have a $5,000 tax credit. Pause for a moment. We'll go down this rabbit trail for a moment. In the hierarchy of benefits, tax benefits, tax credits are at the top of the list because tax credits are essentially the IRS giving you money for doing something. Unlike the next level down, which would be a tax deduction, right? So a tax deduction means I had to spend $1 on something, or whatever amount it was, but I have to spend money on something, and then I get to deduct it. That's great, but if I'm in the 30% tax bracket, for example, that means it only saved me 30 cents for the $1 that I spent. This doesn't do that. This is a $5,000 credit. They're going to hand you a check for $5,000 for 3 years for startup plans. So what they're doing, what they're saying here is, look, if you're a small business owner or any size business owner, and you don't have a 401k plan in place, any type of retirement plan, by the way, simple SEPs, any type of retirement plan, we will give you up to a $5,000 credit for 3 years to put a plan in place. And if you create an auto enrollment feature within that plan, we'll also give you another $500 bonus. Now, auto enrollment is something that it's kind of complicated. And again, we're not talking about pension plans in general here, so I won't go down that rabbit trail, but it's another $500. So again, the government is trying to give businesses incentives to create these retirement plans for their employees. Here's another one, multi-employer plans. They're called MEPs. Now, what MEPs do is they allow a multiple of companies. So let's say that you have a friend that owns a flower shop, and you own a car repair shop, and somebody else owns a retail store. Well, before, you each would have had your own retirement plans, and you would have to bear the costs of setting up and administrating those plans. Well, now you can band together if you want to, and you can create one plan and put all your employees into this this MEP. So the good news is you reduce the costs. You divide them up by 3, in my example, 3 employers, and over multiple employees. The bad news is you now got partners in your retirement plan. You better hope you all get along. But it's still, again, encouraging small businesses of all sizes, really, to put a retirement plan together. And this is a way to minimize some of those costs. The next one, the 15% salary deferral, doesn't affect a lot of people, but this is for plans that have auto enrollment, as I mentioned before. It was a 10% increase to the auto enrollment per year. Now it's 15%. And again, the idea there is it allows the employer to basically, in this example, force, they call it they should call it forced enrollment, because it forces the employee to contribute into the plan, but it gives them a way to increase that so that, again, the employee can do the right thing and save for their retirement. This next one is a big one, at least in my mind, private portable pension plans. So I mentioned earlier that the pension plans have pretty much gone away starting in the 70s. And today, when we look at our clients, most of them, almost 90% of them that have pensions, they either work for a government, the state, US government, right? The state, the county, a city. They were a teacher, a fireman, a policeman. They did some kind of public job, and those folks still have pensions. Well, they're not the bulk of the population. There's a lot of them, but they're not the bulk of them. And the rest of us have had to rely on 401ks, SEPs and Simples, and IRAs to save for our retirement money. Those plans, those 401k plans, for example, they're not pensions. Pensions pay an ongoing lifetime income benefit, maybe even for two people, the owner and the spouse, guaranteed lifetime income benefit. 401ks, IRAs, simple SEPs are tax preferred savings plans. So in most instances, they give you the ability to put money in pre-tax, so you get to put a whole dollar in instead of an after-tax dollar, and then all those dollars inside the plan are going to grow tax deferred, but as we talked about earlier, they're going to come out taxable, but they're going to come out in the form of a withdrawal, not as a pension. It's not a guarantee. It's just whatever you're going to take out, you're going to take out. Well, that's changed with this law. What they're going to do now is allow us to put annuities inside of a 401k plan, which is a wonderful thing, because now that will provide a pension like benefit to the owner of the 401k, because what do annuities do? They take money, a chunk of money, and then they convert it into an ongoing guaranteed lifetime income benefit that can be for one or both spouses, right? And the other benefit of this change in the law is if you change employers, if you change employers today, you can roll your money in your company's sponsored plan from the old company to the new one or into an IRA. Well, you'll be able to move these annuities as well. And that's why I call them private portable pension plans. They're pension plans inside your 401k that you get to create, and you get to move them with you if you change jobs. I think it's a really big and going to be a powerful thing and a huge benefit to millions of Americans. Another biggie is this one, no age limit for IRA contributions. So prior to this law, if you had worked for an employer and the employer had a 401k, even after the age 70 and a half, you could contribute into that plan. You were allowed to do that, but IRAs couldn't do it. Now they've made that equal. So whether you have an IRA or a 401k, you can go all the way up to age 72 and make contributions. And if I didn't mention this previously, I'll mention this again. They changed the age that RMDs required from 70 and a half to 72. So they gave us more time to let that money be deferred. And so now no RMDs until age 72. This is another big one for a lot of people, 401ks for part-time workers. It's really designed for the spouse, the stay-at-home spouse, if you will, the spouse with the child that that doesn't want to work full-time or can't work full-time or chooses not to work full-time, but still allows them to participate in a 401k retirement plan. Previously, before this law was enacted, most plans required that you had to have at least 1,000 hours, that's considered full-time, of work in a year in order to participate in the plan. And as a result, a lot of people weren't able to do that. Well, now they lowered that to 500 hours. So again, it's the government encouraging workers to save for their retirement. And now even if you take a leave of absence or get your hours cut back and now you don't work a full shift, whatever, you'll still be able to be eligible for a 401k plan. I think that's a big deal. Another one, it's a new one, not a huge deal, it's a $5,000 deal, but penalty-free withdrawals for new parents. So parents having a new child can withdraw $5,000 from their retirement plan and it won't be subject to the penalty. They'll got to pay the taxes, but it won't be subject to the penalty. Should they do it? No. I mean, the idea of the retirement plan is to put money in for retirement, not to pay for babies. But if you have to do it, it's nice to know you can get your money out without having to pay an additional penalty to do it. Penalty-free withdrawals from 529s to pay student loans. This is an interesting one. So why in general, I'm not a big fan of 529s, and we'll do a webinar on that as well in the future here, near future. 529s have their benefits, right? You can put after-tax money into them, and then once the money's inside the 529, the investments can grow tax-deferred, and as long as the money is spent on for educational purposes, that money and all the growth from that money can come out tax-free. That's a wonderful thing, right? Problem is if you got student loans, you use the student loans to pay for a lot of those expenses. So in the past, 529s, the 529s were going to pay for the expenses that the student loans did. So now the money's sitting in the 529. If you take it out, it's going to get taxed, right? So they changed that a little bit. They're going to allow 529s. You can take $10,000 out of the 529 to pay for student loans. Again, for a lot of the student loans I see coming through my office, which are horrendous, $10,000 isn't going to make a significant dent, but it's nice to know that that's still $10,000 you can pull out of a 529. They now consider that an expense, and it comes out without the penalties or the taxes. And then the last one on my list here, my long list, is expenses for postgraduate study and foster care is now considered compensation. Now, why is that important? Well, to contribute to a retirement plan, you have to have earned income. You have to have compensation. And so they changed the law and they said, look, if you're going to go to graduate school and spend money on that to further your career, we're going to allow you to consider that as compensation, that money you're spending. And then based on the amount of money you spend, you'll be able to make a contribution into your 401k or SEP or whatever retirement plan you choose. And foster care, of course, is work. And now they're considering foster care as compensation again, so you can make contributions to a 401k plan. And I laughed a little bit about that, but really foster care parents are amazing people and they do wonderful things for these children. And this is wonderful for them now because they have a way, because of what they're doing, to contribute to a retirement plan for themselves as well. So we like that. Okay, so this is coming to the end of the webinar. I promised you 30 minutes. I think we're going to get it done a little bit less than that. But we talked about a lot of things tonight. This entire webinar will be recorded. I would encourage you, once you get the link to the recording, to pass it along to friends and relatives, coworkers. This is going to affect almost everybody. And we're also going to make available to you this guide, this financial guide with the new retirement rules. Now, this is one of many guides that we have. We actually have, I think, 12 guides currently that you can obtain also through our Financial Independence Toolkit. and they cover various topics from Social Security, caregiving, college education. There's a whole wide variety of them, and now we have another one, the New Retirement Rules Secure Act of 2019. So most all of the things that I talked to you about in this webinar are included in this guide. There's a couple special things that I brought in because they're relevant. They're just not on the guide, but I wanted to get them out onto the webinar today. So this guide will be provided to you along with the recording of the webinar. It will be available always on our website, which is lifetimeparadigm.com, and we will email instructions to anybody who registered for this live webinar so that they can download a link directly to get this guide as well. Next, if you want more information, we talked about a lot of things. I talked about them pretty quickly. You can send us an email at info@lifetimeparadigm.com. You can always call us. We have an 800 number. And then for most people, it's just easier to schedule a one-on-one appointment. And the easiest way to do that is just go to our website, lifetimeparadigm.com. There's a little pop-up there, and you can schedule a convenient time. We have clients all over the country from the East Coast all the way to Hawaii, and this will adjust for your time zone and make sure that that there's a spot available for you to talk with us one-on-one. So with that, again, I want to thank all of you for taking your time to learn something new. This is a very big deal, the Secure Act of 2019. I found that a lot of advisors and other financial professionals, whether they're attorneys, administrators, they're really not up on this yet. So in many ways, you're getting a head start on this, and it is important. You bet it is, because it's going to affect almost everybody who has money in a retirement account today. These rules are significant. So again, thank you for joining us, and we'll see you next time when we give our next workshop, our next webinar. Look for that email and be sure to register. Thanks, and bye for now.